Good morning, and thank you on behalf of the Arkansas Department of Education, Elementary and Secondary Education, and the Equity Assistance Center for joining us as we shine a light on Title IX Amendment Act of 1972. I am Oliver Dillingham, Program Manager of the Equity Center. The vision of the Arkansas Department of Elementary and Secondary Education is transforming Arkansas to lead the nation in student-focused education. The mission of the Arkansas Department of Elementary and Secondary Education is providing leadership, support, and services to schools, to districts, and to communities so that every student graduates prepared for college and career and community engagement. In 1985, the Arkansas Department of Elementary and Secondary Education was authorized to establish a special section within its organization to be known as the Equity Assistance Center, to be designed to provide assistance to school districts of the state in such activities as affirmative action, program accessibility, human relations, awareness, and desegregation. This assistance shall include on-site visits, workshops, program reviews, and any other special activity which might enable the school districts of the state to more effectively meet their civil rights responsibilities. The center shall maintain manuals, guidelines, procedures, and other informational materials setting requirements in the area of civil rights and describing how determination of compliance is made. The Equity Assistance Center defines equity as a product of a process that ensures fairness for every child within the educational system. The concept of educational equity recognizes that some students may receive differential treatment in order to achieve fairness within the educational system. One of the goals of the Equity Assistance Center is for every student in Arkansas public school to attend school in an environment that is safe and conducive for learning, and where every student will have an equitable opportunity to receive a quality education that is free from discrimination. We all should agree that having the right environment for all students to learn is a major goal. The first step to a right environment is a safe environment free from harm. The second step is an environment of trust and encouragement. Most educators believe that rules and procedures are a necessary part of school life. The U.S. Department of Education believes that procedures are a necessary part of compliance with civil rights laws. The U.S. Department of Education for Civil Rights has the responsibility of assisting compliance with civil rights laws, as well as enforcing compliance. This assistance to comply with civil rights laws is provided through letters of guidance and regulations of compliance. The Office for Civil Rights enforces procedures or complaint reviews and compliance investigation. Since 1972, the U.S. Department of Education has issued some 33 plus guidance to assist school districts in complying with Title IX of the Amendment Act of 1972. In May of 2020, we received new regulations to comply with Title IX. These new regulations are changes that require schools and districts to discontinue some procedures and implement new procedures in order to be in compliance with Title IX. Title IX is a comprehensive federal law that prohibits discrimination based on sex in federal funded educational programs and activities. Quote, no person in the United States shall, on the basis of sex, be excluded from participating in, be denied the benefits of, or be subjected to discrimination under any educational program or activity receiving federal financial assistance. This morning, The Equity Assistance Center staff will shine a light on Title IX Amendment Act of 1972. I am very proud to have the Equity Assistance Center and for the center to shine a light on Title IX. They will shine a light on Title IX's new regulations that rescinded many of the previous guidance. These regulations became effective August the 14th, 2020.
Hello, everyone. My name is Sonia Johnson, and I'm a program advisor here with the Equity Assistance Center. So let's start off by discussing some of the terms used in Title IX. Generally speaking, sex discrimination involves treating someone differently or unfavorably because of their sex. It's a broad umbrella term, but in terms of Title IX, sex discrimination is the differential treatment of an individual because of their sex within the education setting. So this could be excluding a person, separating them, or denying them benefits in the program. Protections against Title IX sex discrimination applies to both students and employees. Examples of student Title IX sex discrimination we saw in the previous slide include athletic opportunities or unequal opportunities or sex-based discrimination in STEM courses, discrimination based on pregnancy, or sexual harassment. So as Title IX prohibits varying forms of sex discrimination, Title IX sexual harassment is one form of Title IX sex discrimination. There are multiple definitions of sexual harassment. So using the term Title IX sexual harassment acknowledges that there are other definitions, such as the definition of sexual harassment in Title VII of the Civil Rights Act of 1964 regarding the workplace, or the court's interpretation of the Arkansas Civil Rights Act concerning sexual harassment. Institutions must comply with all state and federal regulations, so it's important to use the term Title IX sexual harassment when engaging in this process. Before we dive into the definition of Title IX sexual harassment, let's state what it is not. The Title IX sexual harassment definition does not specifically mention discrimination on the basis of sexual orientation or gender identity. The Title IX sexual harassment definition focuses on prohibiting a specific conduct directed at any individual, no matter their sexual orientation or gender identity. So Title VII of the Civil Rights Act and the big picture law of Title IX sex discrimination protects against discrimination on the basis of sexual orientation and gender identity. So let's examine the specific conduct and behavior prohibited in the Title IX definition of sexual harassment. Here we see the three prongs of the Title IX sexual harassment definition. And it defines sexual harassment broadly because those acts jeopardize a student's equal access to education. Title IX sexual harassment conduct must satisfy one or more of the following. The first, when an employee of the institution conditions the delivery of an aid or a benefit or a service on another individual's participation in an unwelcome sexual conduct. This is often referred to as quid pro quo harassment. If this, then that type scenarios. This could be a student's participation in unwelcome sexual advances in order for them to participate in some aspect of the educational program or to have a particular educational decision be made. Title IX sexual harassment could also be unwelcome conduct that a reasonable person would find severe, pervasive, and objectively offensive, so much that it denies access to education. So the conduct must be unwelcome to the individual. This could be unwelcome verbal or nonverbal gestures or comments or unwelcome physical or sexual advances. This prong would not include all offensive remarks because the conduct must include all three elements: severe, pervasive, and objectively offensive. Hence the wording of and not or. Other offensive remarks may be addressed by the school in other ways outside of their Title IX processes. This statute requires that a reasonable person under this prong must determine the presence of those three elements and the denial of equal access. Now, the third prong, Title IX sexual harassment, also includes the offenses of sexual assault, dating violence, domestic violence, or stalking based on sex. So the new Title IX rules cemented these acts as forms of Title IX sexual harassment. When conduct on the basis of sex meets one or more of these categories, the conduct is sexual harassment under the new Title IX rule. And it's essential for everyone, particularly Title IX investigators, decision makers, to understand the definition in a very real way, because this plays a part in the gathering of evidence and the making determinations of responsibility. The terms within the definition need to be understood in practical ways, meaning what's considered severe by a reasonable person, or what's considered pervasive or objectively offensive. How are we understanding the term unwelcome? Does not complaining still mean that the conduct was unwelcome? So some of the terms are left for the school to decide, and then others have been defined for us in the regulations. Reflecting on the full meaning of the terms in this sexual harassment definition in Title IX will better aid our processes and our implementation. Let's look further at a few of the defined terms in the regulations. Here on this slide, we see the conduct mentioned in the third prong of the Title IX sexual harassment definition. Each of these are considered sex offenses, and they are defined in other federal statutes. Sexual assault is a forcible or a non-forcible sex act. Dating violence is defined as misconduct committed by an individual in a social relationship. And domestic violence is misconduct on the basis of sex between a current or a former partner or a family member. And stalking under Title IX is misconduct based on sex that causes the student to fear for safety or causes them substantial emotional distress. So two things in there. As I stated, these are sex offenses, and they are forms of Title IX sexual harassment. Let's expand our knowledge on the blue section here, the blue column labeled sexual assault offenses. Let's get a little clarity on those. The definition of sexual assault is based on the FBI's Uniform Crime Reporting System, and that's called the National Incident-Based Reporting System. For the sake of time, we're not going to directly read each definition here, but we did want to draw your attention to the definition of fondling that's bolded here. Fondling is the touching of a private body part for the purposes of sexual gratification, which is bolded. Review all of these definitions, and as well as the definition of touching, to make sure we have a clear understanding of the definitions, and that we'll know that any conduct meeting any of these categories are considered sex offenses and also fall under sexual assault as a type of Title IX sexual harassment. As we see here circled in yellow and in italics, several definitions reference the term consent. Title IX does not define consent in regards to sexual assault. The regulations left the defining of consent up to each education setting. Lastly, we're going to review some terms reviewed in the Title IX regulation. Make sure we're all on the same page about a few of these. The complainant is a student or an employee who is listed as the alleged victim of conduct that could constitute Title IX sexual harassment. Regardless of whether the person themselves reported the allegations or a third party, the school must treat a person as a complainant anytime the school becomes aware that they are an alleged victim, even if a formal complaint is never filed. The respondent is the individual that has been alleged to be the perpetrator. And the term recipient is used throughout the federal regulation and will be used throughout this presentation. It refers to any institution, any school, any place or employment that receives federal financial assistance. Now let's discuss some of the major provisions.
So far, we've been talking about what is Title IX, the history of Title IX, and common words defined. Now I will be focusing on the major provisions of the new rule. These are the sections that we will be covering from the actual rules themselves. I personally learn better when I am actually looking at the law. So I wanted to give you this link to this document. This is kind of our go-to of if you want to know everything that has to do with Title IX, this is where you will go to and find it. Now, we are focusing on the new regulations, right? Which most of them have to do with sexual harassment, but there are other components of Title IX. So if you have a question in regards to anything Title IX, this is where you can go to read it. The parts that we will be focusing on is right here, 106.8, which is a new section that was added. And let me point this part out. 106.44 has to deal with the general response to sexual harassment. And we will talk about that often, the general response to sexual harassment. And then 106.45 is the grievance process for formal complaints of sexual harassment. So I just wanted to give you a visual of where you can go to actually read the regulations if you wanted to do so, if you have more questions. Let's talk about the Title IX personnel team. That's what we like to call it here at the Equity Assistance Center. The first person is the Title IX coordinator. They are responsible for coordinating the recipient's efforts to comply with Title IX responsibilities. So this means your go-to person in your school district that knows everything related to Title IX should be the Title IX coordinator. And they are authorized. If you notice, I have that in quotes there, authorized. That is in the regs. They must be authorized to do their job. They must be an employee. It specifically says must be an employee or an employees. So that does give you the option for a school district or recipient to pick if they want one Title IX coordinator or if they want several Title IX coordinators. A question that we have been asked is, okay, does it need to be a licensed teacher? Like, do they have to be a licensed individual in order to be the Title IX coordinator? Well, the regs do not say anything about that. So it doesn't say that that is necessary. All it does specifically say is that they must be an employee or employees. They are responsible for the effective implementation of supportive measures and remedies, and we will discuss what those are. And they must be readily available and accessible. That language is not in the regs, but it is stated in one of OCR's webinars, and we've taken it from those sections right there, is that they must be readily available and accessible. Let's talk about the investigators. They are to conduct the investigations and create an investigative report. So who's supposed to create the investigative report? The investigator. And then last but not least is the decision makers. One of their roles is to evaluate evidence and apply the standard of evidence chosen. Why did we say apply the standard of evidence chosen? Why didn't we just say apply such and such standard? Because recipients, school districts need to make a decision on whether they will use the preponderance of evidence standard or the clear and convincing standard. So you have a choice to make, and Lance will go into the specifics of what those look like. And then a decision maker must reach conclusions whether the respondent is responsible for the alleged harassment, whether remedies will be provided to the complainants, and appropriate disciplinary consequences. So does the Title IX coordinator decide what the appropriate disciplinary consequences is? No. Does the investigator decide? No, the decision maker is the one who decides the appropriate disciplinary consequences for the respondent. The decision maker will make two forms of, well, there are actually two forms of decisions. Let me go into this a little bit more. There's the written determination regarding responsibility. So at the end of the investigation, there's a written determination regarding responsibility. Then there's also a written decision and an appeal. Decision makers make these two decisions, but follow me, stay with me. The decision maker that made that written determination cannot be the same person that makes the decision in an appeal. So technically, when we talk about the three groups, right, we have the Title IX coordinator, the investigators, and the decision makers. Although there's three categories, we're really talking about four groups, because in the decision makers, we have determination and appeals. And you might ask, okay, why didn't you just do four categories? Title IX coordinators, investigators, determination, and appeals. Well, when you hear the words decision makers in the law, they're talking to both sets. So that's why, as I laid it out, it made more sense. Three groups, and then know that within the decision makers, there's the ones that make the determination and the ones that make the appeal, and they cannot be the same individual or group of individuals. Here's another interesting fact, and you all probably have heard about this. The Title IX coordinator and the investigator cannot be decision makers. So here, I have a question for you to answer this in your mind or out loud, however you choose. Can the Title IX coordinator be the investigator? Technically, Yeah, they can. The Title IX coordinator could be the investigator. They could, if that's what you would like. But can the Title IX coordinator make the written decision in an appeal? So we have that first, the Title IX coordinators all the way on the left. The appeal is a decision maker all the way on the right. Can the Title IX coordinator make the decision in an appeal? No, they cannot, because a Title IX coordinator and an investigator cannot be a decision maker. So on this screen, if you notice sex discrimination and the grievance procedure versus Title IX sexual harassment and the grievance process. Both of these sound a little similar, right? Grievance procedure, grievance process. But when we hear the word grievance procedure, we're talking about sex discrimination. Remember how Lasagna was talking about the big picture law? So whenever you hear and as you read through the regs and you see grievance procedure, we're talking about all sex discrimination. Those discrimination in STEM, pregnancy students, all of that is covered under that topic. Now, when you hear grievance process, they are specifically talking about Title IX sexual harassment. And that's very important as we move along to know which topic are we talking about. Are we only talking about sexual harassment or are we talking about the big picture law? So reporting sex discrimination can be by any person, anytime, verbal or written. Any person can make a report. So if there is someone in your community that feels that a pregnant student is being discriminated against, they can report that to the Title IX coordinator. Any person, anytime, verbal or written. And if you notice under any person, it says whether or not the person reporting is a person alleged to be the victim. The goal behind this is to give everyone an opportunity to be able to report. So no longer is it that only the victim is the one that can come forward and report. Anyone can report. So if there's a family member that knows that dating violence is going on, they can make that report to the Title IX coordinator at any time during business or non-business hours, which is why that contact information needs to be readily available. And if you see this, it can be made in person, by mail, telephone, or email, and it lets you know where the contact information needs to be. And required parties, there's a definition on the bottom if you want to know, okay, what is a required party? It's listed there for you. These three items are the ones that need to be posted on your website. Contact information for the Title IX coordinator, the non-discrimination policy, and also the training materials used. All three of these items need to be on your website. Now, specifically in the law, it has this verbiage of prominently display under the contact information and the non-discrimination policy. So something that I suggest is, why don't you have somebody that maybe is not too familiar with Title IX and ask them, hey, can you go on our website and see if you could find, this about Title IX and see how long it takes them to find it. If it takes them quite a bit, and I've gone to some school districts where I was like, whoa, this is really nice. It's like right here. It's like, I don't even have to take long to find it. There it is, Title IX, there's their training materials, there's the contact information, there's their non-discrimination policy. And then in other school districts, it's taken me a minute. I'm even doing like the search on there. Where's the search? Where is this? Where, it must be at least, it says for those two, but since you're at it, why not make all of that prominently displayed? Now we're going to talk about Title IX sexual harassment. Our general response to Title IX sexual harassment, which is found in 106.44, states that a recipient with actual knowledge of sexual harassment must respond. So when we see this definition of actual knowledge, it means a report, notice of Title IX sexual harassment or allegations of Title IX sexual harassment to a recipient's Title IX coordinator, or get this one's interesting, or to any employee of an elementary and secondary school. So a school is on notice, they have actual knowledge of a report of sexual harassment. So like I said, now we switch. First, we're talking about reporting of sex discrimination. Now we're focusing strictly on sexual harassment. So that report of sexual harassment, the school is on notice, the school has actual knowledge when that report is given to any employee. That's your teachers, cafeteria workers, office staff, anybody. And in OCR's short webinar on how to report sexual harassment, they even say that those who are under contract to the school. So any employee literally means any employee. When that happens, what should be the general response to Title IX sexual harassment? You must respond promptly. You must respond equitably. And it gives the example there by offering, so how could you be equitable to both parties involved? By offering supportive measures to the complainant and by following a grievance process before imposing any disciplinary sanction. Are you telling me that if I get a report of sexual harassment, I can't punish the alleged respondent, or I can't put, any kind of disciplinary sanction on them until the conclusion of the grievance process? Yes, that's actually exactly what we're saying, because before any disciplinary sanctions, and we'll talk about a different supportive measures in a minute, but before any disciplinary sanction can be imposed on the alleged respondent, it has to be until the conclusion of the grievance process. That is how you could show that you're being equitable to both. Discuss supportive measures. Discuss the availability with the complainant, and then the last bullet there is availability with or without a formal complaint. So these supportive measures, when you're discussing it with the complainant, you must let them know that they're available whether they file a formal complaint or whether they don't. Supportive measures are supposed to be in place for them. Now explain the formal complaint. The formal complaint is a document filed by a complainant or signed by the Title IX coordinator. Now there's two parts to a formal complaint. Number one, alleging Title IX sexual harassment against a respondent. And number two, this is key, requesting that the recipient investigate the allegation. When a complainant decides to file a formal complaint, because this is part of what your Title IX coordinator, you're explaining to them, right? This is what a formal complaint is. If they file that, what that is, it's they're alleging that sexual harassment happened against the respondent, and they're requesting the school to investigate it. But with all of this, even though supportive measures are supposed to be in place, there is room for emergency removal or administrator leave under certain conditions. So I just wanted to throw that out there that is an option, but there are rules that go with that. Okay, here's our guidelines for a formal complaint. Complainant must be participating in or attempting to participate in the education program when the formal complaint is filed. The parent or guardian may file a formal complaint on behalf of the complainant. So that is possible. I believe it is 106.6G is where you can find that in the law if you want to see it directly. And then a document filed by a complainant means a document with the complainant's physical signature or an electronic submission with a digital signature. So that's just some guidelines there for you to see. Let's make the switch to supportive measures. The key of supportive measures that they are designed to restore or preserve equal access. So that's what we have to keep in mind as you're deciding what your supportive measures are, is they're designed to restore or preserve equal access. And then you can read the rest of that definition. Supportive measures are individualized services to be available to complainant and the respondent. They're non-disciplinary and non-punitive. Remember, that aligns with previously how we had to treat them equitably, right? So they're non-disciplinary and non-punitive, offered as appropriate, without a fee, to be maintained as confidential, but to the extent that maintaining such confidentiality would not impair the ability of the recipient to provide the supportive measures. So the automatic, the go-to definitely is to maintain confidentiality, but you have to be able to still provide that supportive measures. And it is the responsibility of the Title IX coordinator to coordinate the effective implementation. So Title IX coordinators that are out there, the supportive measures are on you, and also the remedies for the effective implementation, and they must be documented for 7 years. So when we look at the record keeping of documents for sexual harassment. Now, remember, we're specifically talking about sexual harassment right now. 7 years is pretty much the standard. That's the norm. That's 7 years. And if no supportive measures were provided, let's say for whatever reason there were not supportive measures, the reasons must also be documented. If somebody were to look back on it, they could be able to say, well, why didn't they offer supportive measures in this situation? You have the reasons documented why. A general response to Title IX sexual harassment occurs when a report is made. There's that general response. So everything that we talked about so far in that green with the green slides have to do with the general responses to Title IX sexual harassment, which happens when a report is made. And you can find that in 106.448. Now let's switch over to the grievance process for Title IX sexual harassment that happens when a formal complaint is filed. So at first, there's all of these different things you have to do when a report is made, but then the complainant has to decide if they want to file a formal complaint. And remember, a parent can also file for the complainant. And then a Title IX coordinator can also sign for one. If any of those three happen, and now a formal complaint has happened, let's switch on over to what happens then. There are 8 different components that is supposed to be in every recipient's grievance process. Title IX, formal complaint, sexual harassment. Okay, there's 8 different components. 2 of them are optional, and Lance will discuss, which are your informal resolution and your hearings. Okay, so for those schools that want to do both of those, then you would actually have 10 components, right? But if for the ones that do not choose not to do those 2, at minimum, there's these 8 that's supposed to be in your grievance process. Basic requirements. Let me give you a second to read some of those. Okay, now let's talk about training. We talked about this earlier. Recipients must ensure that the Title IX personnel team receive training. So that's your Title IX coordinator, your investigators, your decision makers, your 2 groups of decision makers. Everyone on your Title IX personnel team must receive training, and there's specific training that we'll go into later. The presumption that respondent is not responsible for alleged conduct until a determination regarding responsibility is made. Remember, that's how you treat the respondent equitably, and a reasonably prompt time frame. There's a link here. I hovered over it so you can see the address of it. But if you Google that, it goes into specifics about COVID-19 and the COVID-19 environment. Within your reasonable prompt time frame, there is a clause there where it says about good cause. Let me read what it says. The ongoing situation related to COVID-19 may, in some circumstances, qualify as good cause under Title IX for reasonably temporary delays, okay, not permanent delays, temporary delays, or tensions of timeframes related to the grievance process. So you can look that up to look up the specifics, but the general rule is you must follow a reasonably prompt timeframes, but there is this good cause that may apply to this COVID-19 time. Okay, the notice of allegation is provided by the recipient, provided to the parties who are known, provided upon receipt of a formal complaint. So once you get that formal complaint from your complainant, you must provide them with the notice of allegations to the parties who are known. It must contain the notice of your grievance process, the notice of the allegations of sexual harassment, and this, it gets good right here, including sufficient details known at the time, which are identities of the parties involved in the incident, the conduct allegedly constituting Title IX sexual harassment, and the date and location of the alleged incident. So this notice of allegation must include sufficient details. Now, you might be thinking, oh my, why do I have to give them so much details? Because in this Title IX, recipients cannot prohibit parties to discuss the allegations. That might sound different from other practices, but you cannot prohibit them from talking about it, and you cannot prohibit them from gathering evidence. So you need to include sufficient details.
And then a statement regarding the respondent is presumed not responsible. We've talked about that a lot. Inform parties that they may have an advisor of their choice, which may be an attorney, if that's what they wish. And then inform parties regarding false statement and false information. During the investigation, if the recipient decides to investigate additional allegations, they must provide notice of the additional allegations. So when you gave that initial allegation, you said this is the allegations. If in the process you find that there's other things that should be investigated, you need to provide notice of additional allegations. Now, dismissing a formal complaint. Here's the decisions for when you must dismiss a formal complaint. If the conduct would not constitute sexual harassment, if the conduct did not occur in your education program or activity, or if it did not occur in the United States. Such dismissal does not preclude action under another provision. So it could still be followed under your discipline policy, but in these three situations, they must be dismissed. Now, if you look at may dismiss, this is when you need to decide. And you can look at those right there. So the middle one, I know the middle one bothers a few people, which is if respondent is no longer enrolled or employed by the recipient, you may dismiss. It doesn't mean you have to dismiss, but it does say that you may dismiss. And then upon dismissal, if you decide on the may, or if you have to because of the must, please note that the recipient must promptly send a written notice of the dismissal and reasons simultaneously to the parties. So both parties must receive that notice that you dismiss. Now, consolidating formal complaints. If there is one complainant and two or more respondents, you can consolidate those formal complaints. If there's two or more complainants, one or more respondent, you can consolidate those. One party and another party, you can consolidate those. But it's where allegations arise out of the same facts or circumstances. An investigation of sexual harassment does not occur until a formal complaint is filed. I believe every report of sexual harassment previously was investigated. Now with the new rules, it's an investigation of sexual harassment does not occur until a formal complaint is filed. And who has the power to decide about that formal complaint? The complainant, the parents of the complainant, or the Title IX coordinator could sign one. The recipient then must investigate the allegations in a formal complaint. So in summary, a report puts recipient on notice. A formal complaint initiates an investigation. Let's look at our investigation guidelines. We must ensure the burden of proof and burden of gathering evidence rest on the recipient, on you, on the ones listening out there. The burden of proof and the burden of gathering evidence rest on the recipient. Provide equal opportunity, that's embedded throughout all of this, equal, equitable. Do not restrict, I said this earlier, the ability of either party to discuss the allegations under investigation or to gather and present evidence, and provide written notice to a party whose participation is invited or expected. So during this investigation, if you have to send notice to the parties. For the investigation, we must first gather the evidence, present evidence to parties, and the writing below says parties have 10 days to submit a written response. So before the investigative report is created, you have to allow for at least minimum of 10 days for parties to submit a written response. So you gather the evidence, you present it to the parties, and then before that investigative report is created, allow 10 days there before that happens. You send the investigative report to parties' decision makers, and there's that 10-day window right there at minimum, 10-day minimum. And then the decision maker will make the decision regarding responsibility. So we talked about the general response Title IX coordinator. We talked about Title IX coordinator investigators in a grievance process. Now let's talk about the decision makers, okay? The decision maker, our third group. They must make the determination regarding responsibility. It must be in written form. You must apply that standard of evidence that the recipients choose. It must include, I'm going to have you read these as I click along. Now on this one, the description of the procedural steps taken, it must be from the point of receipt of a formal complaint all the way to the determination. That description starts with the receipt of a formal complaint all the way to the determination. Okay, so this is what needs to be included in this determination regarding responsibility. Now let's talk about number 5 a little bit more. The statement and rationale for the result of each allegation. It must include these 3 components: a statement and rationale about the determination regarding responsibility, any disciplinary sanction imposed on the respondent, and whether remedies will be provided to the complainant. So it must include these 3 components. And then number 6, procedures and permissible basis. Let's go back to number 5. So if you look at number 5, we were talking about those first 2. Those first 2, the determination regarding responsibility and any disciplinary sanction, that can be determined by one decision maker, one. Or like I mentioned in that blog, OCR has a blog that goes into the decision makers, or it can be made by 2 separate decision makers. One decision maker can make the determination regarding responsibility, and one can make the decision regarding disciplinary sanctions. Okay, you can have both, but they must be contained in one written determination. So if you decide to go that route, it could be one decision maker makes all of those 3, or you can separate it and you have one decision maker make a determination regarding responsibility and one regarding discipline. But either way, you can't have it in different documents. It must be contained in one written determination. And then the remedies will be provided to the complainant. Let's talk about that real quick. Remedies may include the same individualized services as supportive measures. So they could be very similar, other than the fact of that they cannot be, in this case now that it's a remedy, because this happens at the end, once there's the determination regarding responsibility, at that point they can be disciplinary and they can be punitive, and they need not avoid burdening the respondent, because at this point when you use a remedy, it's after the fact that the respondent was found in violation, that they actually committed that, what they were alleged of. Now, let me quickly go through appeals. So an appeal, when can you offer an appeal? You can offer from a determination regarding responsibility and from a recipient's dismissal. Remember that where we had the must dismiss, may dismiss. If you dismiss it, you must offer them an appeal to both parties on the following basis. Now, if you notice, these 2 bases have the wording of actually affected the outcome. So if there was a procedural irregularity that affected the outcome, if there was a conflict of interest or bias that affected the outcome, then you can offer an appeal. Now, the language on this middle one is new evidence that was not reasonably available that could affect the outcome. So if there's a possibility that it could, new evidence in regards to what? In the determination regarding responsibility, or if there's new evidence that you dismissed it before, but now there's evidence that, that could affect the outcome, that's when you can offer an appeal. And the appeal guidelines notify the other party in writing when an appeal is filed, implement appeal procedures equally to both parties. There's that equally again, that's embedded throughout, and give both parties a reasonable, equal opportunity to submit a written statement in support of or challenging the outcome. The written decision in an appeal must describe the result of the appeal and the rationale, and must be provided simultaneously to both parties. So there's that written decision in an appeal. Remember, decision makers, there's that written determination regarding responsibility that happens at the conclusion of an investigation, and there's a written decision in appeal that happens at the conclusion of an appeal. And let's review. Can the same person that made the written determination make the written decision in an appeal? No, 2 separate decision makers.
One of the big ones was if you not investigate the incident until a formal complaint is filed, do you do a normal investigation like any general incident that happens in school? If you do investigate a general incident, then a complainant files a formal complaint. Have you violated the respondent's rights by interviewing without offering representation? I'm going to give the simple answer. If you have acknowledged that there is a potential of sexual harassment under Title Ix sexual harassment, then you must follow the process. If no formal complaint is filed, the Title IX coordinator can file a formal complaint. If you determine that an investigation needs to happen, I guess my question is, if you feel it needs to be investigated, why would the Title IX coordinator not go ahead and file that formal complaint? But if you have Title IX sexual harassment and you don't follow due process and it follows under there, then yes, you have potentially, I would think you have potentially violated the right. I will also add at this point, we're giving you the guidance based on understanding we are not lawyers and not able to give you official legal advice. You would need to visit with your counsel to make sure that they review these processes. Anybody else want to jump in to answer that if you think maybe that would go a different direction?
I would add to it just the next response would be also, in addition to what you just said, is to offer those supportive measures to that complainant and then to share with them the process of how to file a complaint, a formal complaint, if they want to do that. So I just wanted to add those two things.
Those supportive measures have to be available to the respondent as well. Once a staff member is put on notice that an incident could be sexual harassment and they report it, the next steps, according to the protocol, the Title IX coordinator should be notified immediately. Then it's the Title IX coordinator's responsibility to contact the complainant and discuss the process and give the procedures and how to file a formal complaint and to offer supportive measures for them. So that goes straight to the Title IX coordinator. And if you do not investigate a sexual harassment, then would you make a determination that it is not sexual harassment before a formal complaint? If you do not investigate as sexual harassment and as Title IX sexual harassment, then would you make a determination that it is not sexual harassment before a formal complaint was filed? We don't really make a determination, but here's the thing, and you guys jump in as I'm explaining this. In the guidance from OCR, they make it clear OCR does not have the authority to direct you to investigate things that are not defined under Title IX as sexual discrimination. And the sexual harassment is now defined. And so they made that very clear in their guidelines. We cannot give you guidance or require you to investigate a certain way unless it fits these definitions of Title IX sexual harassment. So that would be why the Title IX coordinator has to be trained in sexual harassment, Title IX sexual harassment, and what is defined as such, so that they can move forward in relation to a formal complaint when something clearly falls under the rule of Title IX sexual harassment. And that's how they leave it. They don't really go further than that in answering the question that you've given here, except to state that they can't hold you accountable for investigating and not following due process lined out in Title IX if it is not what is defined as Title IX sexual harassment.
Okay, so let's have a quick view or fun review of what we've kind of already discussed. Pretty much the questions are going to be fairly easy. They're just a review of what we've immediately just talked about, just so that we can kind of reinstill in our brain some of those really important things that we can just hopefully recall real quickly. And that's really the whole purpose. So it's not going to be terribly hard, but if there's 6 questions and they're about 20 to 30 seconds time frame to allow y'all to read them and pick your answers. So here's the first question. The purpose of Title IX's prohibition of sexual harassment is because that misconduct jeopardizes blank. So fill in the blank: a student's grades and reputation, an employee's pay and reputation, an individual's equal access to education, or the activity, or the school's accreditation. And so here we see people who are answering. And then that's the answer in blue: an individual's equal access to education or the activity. So the Title IX sexual harassment can deny an individual's equal access to education or to the activity. So this phrase is referenced throughout Title IX. And for this reason, remedies provided to the complainant must be designed to restore or preserve that access. So that's just an important phrase to remember, because everything, that's kind of the ultimate intent, the ultimate goal of all of this is to restore that equal access to education. And here are the standings if you're curious. Next question: unwelcome conduct that a reasonable person would find blank blank and blank, so much that it denies access to education. So the blanks, a simple, persistent, objectively offensive, severe, pervasive, objectively offensive, or severe, pervasive, objectively aggressive. Which one of those answers, remembering this is going to the second prong that we discussed in the sexual harassment definition. All right, we're almost down to 2, 1. The answer is severe, pervasive, and objectively offensive. Awesome. So Title IX sexual harassment conduct under this prong must have all 3 of those things and effectively deny a person equal access. So as determined by a reasonable person. So a reasonable person must determine the elements of these 3 things and the denial of equal access. And here are the new standings. Wow, good job, Owlie. All right, question 2. 3, what are the 4 sex offenses that are forms of Title IX sexual harassment? So were they sexual assault, dating violence, domestic violence, and stalking, sexual assault, dating violence, abduction, and stalking, or sexual assault, dating violence, domestic violence, and pornography? Down to the next 5 seconds. And the answer is the first one, the red one, sexual assault, dating violence, domestic violence, and stalking. So a single instance of these sex offenses are deemed so severe that they deny a person equal access. There is no need to consider for this prong if these specific acts are severe, pervasive, or objectively offensive. Remember, that's the middle prong. Under this prong to be considered Title IX sexual harassment, all you have to have is have these conducts being there. And let's see how the scoreboard looks now. Okay, so question 4 is who must contact the complainant confidentially to discuss the availability of supportive measures? Was this person the investigator, the decision maker, the Title VII coordinator, or the Title IX coordinator? Who was contacting confidentially the complainant to discuss the availability of these supportive measures? Well, that was the Title IX coordinator. So they must make prompt contact with the complainant to discuss the availability of supportive measures with or without the filing of a formal complaint. And they must consider the complainant's wishes and explain the process for filing a formal complaint. All right, the new scoreboard. And then question 5 is a true or false question. So the district must decide if they will investigate every formal complaint of the Title IX sexual harassment. So is that something that they have to decide if they were going to investigate every complaint, every formal complaint? True or false? Have about 5 more seconds. That is actually false. So the final Title IX rule requires the investigation of every Title IX sexual harassment allegation that is within a submitted formal complaint, which can be filed by a complainant or signed by a Title IX coordinator. So every submitted formal complaint must be investigated. That is not a decision that has to be made. And the last question, oh, here are the standings again. Wow, good job. So here's the last question, question 6, also true or false. A report of Title IX sexual harassment and a formal complaint of Title IX sexual harassment are different. So are those 2 things different? Is there a difference between a report or a formal complaint of Title IX sexual harassment? True or false?
I can feel the intensity of this Kahoot coming through the screen of everybody.
All right, the answer is true. They are different. So a report of sex discrimination, including Title IX sexual harassment, can be made in person, by mail, by telephone, or by email, or can even be verbal or a written report. But a formal complaint of Title IX sexual harassment is a document filed by a complainant or signed by a Title IX coordinator alleging sexual harassment and requesting that the school investigate that alleged sexual harassment. So that was fun. I actually really enjoyed that. I hope you guys enjoyed that too. And that actually brings, here's the score. Good job, Gigi. The next thing we're going to talk about is how to serve impartially. And we appreciate everyone for participating in that game. Thank you so much. So the Title IX regulations require that designated individuals not have a conflict of interest or bias. So this applies to Title IX coordinators, investigators, decision makers, and facilitators of informal resolution processes if you guys decide to have informal resolutions. So impartiality is integral to the Title IX formal grievance process. It's the ability to remain neutral and means to perform actions fairly and to have decisions based on an objective criteria. So designated individuals must be equitable with all parties and in their actions, in their considerations, and in their decisions. They must be impartial. So what can influence a person's ability to be impartial? Individuals who are partial might be influenced by, among other things, their prejudgment of the facts at issue, their conflicts of interest, or their biases. Prejudgment of the facts at issue is to pass judgment too early without adequate consideration. So an example would be when because a student is visibly upset during questioning, we prematurely conclude in our minds that they are telling the full truth. But a good rule of thumb is to keep an open mind and not pass judgment one way or the other until, as the decision maker, you're at that final point. So if we do prejudge the facts, this might influence how we collect the data or how we collect evidence or what we say to the parties, even if we don't realizing it's influencing us. Steering away from any prejudgment is the best rule of thumb. An example of conflict of interest could be if the Title IX investigator's child is close friends, say, with the respondent or with the complainant. This relationship and familiarity might compromise the investigation and your approach if you're a Title IX investigator. So a good rule of thumb would be to ask yourself, would I be comfortable if this conflict, if this familiar relationship or affiliation appeared publicly in the media or with the parents in regards to my work in this complaint? Just always kind of ask yourself those questions. Am I being biased? Am I considering all the facts? An example of a bias could be to stereotype women complainants, for example. So such as believing that women are only making allegations now because of the Me Too movement that's occurring right now and not because of any actual experiences that they're engaged in. Bias is the tendency to be for or against an individual or a group that leads to a prejudgment of the facts we just talked about. So a bias can lead to prejudgment. There can be bias for or against women, for or against men, or for or against all complainants, or for or against all respondents. So, or an individual's sexual orientation, you can have bias against that. A good rule of thumb is to focus on the facts and not our personal opinions. We should ask ourselves, am I assuming things or am I relying on the evidence that's presented? Preventing bias, conflict of interest, and prejudgment of the facts are some of the ways that an individual can remain impartial. To serve impartially, individuals must first be trained. So the final regulations state that training must include, amongst other things, how to serve impartially, including making sure that we're constantly mitigating ourselves and avoiding prejudgment of the facts at issue or our conflicts or interests and biases. Also, another way to serve impartially is to, at the start of your assigned role in a complaint, kind of assess that you are free of any form of partiality. So consider if you are able to be objective in regards to the form of complaint. Consider if you have any conflicts or interests or familiarity with any of the parties involved in the complaint. Individuals should come into their roles without conflict and avoid all stereotypes right out of the gate. A true assessment of yourself or where you are and awareness of how your own experiences impact you and impact your actions. So always just be mindful of self and what you're doing. Never just completely say, well, I'm not biased or I don't have any conflict of interest and just completely disregard it. But always kind of bring yourself back to those questions and making sure that I'm impartial, making sure that I'm considering all sides of the story. Third, individuals in these roles should state when they cannot be impartial in regards to the complaint. Just simply saying, I know this person personally, or you can say, I know this respondent has had similar allegations in the past, and this might influence my actions, or I'm uncomfortable. Or you can say most of the respondents in our school tend to be guilty, if you honestly feel that way. So just feel free to assess your situation and then sharing it with others when you can't be impartial. Individuals have the right and the obligation actually to say that they cannot be impartial. No one should feel that they have an unfettered duty to be in the role when they cannot be impartial, and should not be penalized for disclosing that. People should actually be encouraged to express when they can't be impartial. With this in mind, it may be needed to identify and train alternates for the roles, to have people available in case someone needs to make that kind of claim and recluse themselves from the complaint. It's better to assert any issue of lack of impartiality early on in the process as much as possible. Lastly, in their respective roles, Title IX investigators and decision makers would need to objectively gather and evaluate evidence, including inculpatory and exculpatory evidence. For the investigator, for example, we should seek out information that shows the respondent as responsible to the Title IX sexual harassment conduct, as well as shows that the respondent was not responsible to the conduct. We cannot only look at to one side of the evidence to serve impartially, but have to gather all sides of the evidence and then leaving the decision maker to objectively evaluate all sides of the evidence. Issues related to any conflict of interest or any bias might be a grounds for an appeal. Next, let's talk about confidentiality in regards to Title IX. Everyone should be mindful of the need to be confidential while doing this work. There's an expectation that schools maintain confidential the identity of the individual submitting a report or a complaint, and the identity of the alleged victim or the alleged perpetrator or any witnesses, and confidential any supportive measures that are provided to the complainant or to the respondent. So there are 3 exceptions to Title IX confidentiality that we see on this slide. So information can be shared as permitted by the Family Educational Records Protection Act, FERPA, and it prohibits the disclosure of personally identifiable educational records without the parent's written permission. And we'll discuss FERPA further in this training, but another exception would be as required by law. So such as the Arkansas mandated reporter law, to notify law enforcement of serious and imminent threats to the public, or any other law. And then the third exception to confidentiality can be to share information in order to carry out the Title IX regulations. So an example of this would be to provide supportive measures. Some measures can't be put into place without other people knowing about the measure. And this could be a schedule change or anything like that. So confidentiality, that's an exception to confidentiality when you have to implement supportive measures. Also, confidentiality should not prevent an adequate investigation or due process. This exemption still allows for meaningful participation to discuss allegations, gather, present, and inspect evidence. The regulations specifically state that retaliation is not acceptable. So no school or person can intimidate, threaten, coerce, punish, or discriminate against any individual for exercising their Title IX rights, or for reporting a Title IX complaint, or for participating in any part of the Title IX process. Retaliation is prohibited, and a part of school policies should reflect the expectation that retaliation is prohibited. Complaints alleging retaliation can be filed according to your grievance procedures for Title IX sex discrimination, the big picture law.
I want everybody to take a minute, take a deep breath, because we've gone through a lot of information. And what I'm going to be doing in this next part here is I'm going to go over a few decisions that you need to make as a district, as well as some of that impact of what it looks like now compared to what it may have looked like in the past. Having just left building level administration and having done district level administration, there's some impacts, there's some processes that we're not used to that now come into play with this. There are 3 major things that are left in here for the district to decide. We're going to talk about each of these. First, are you going to provide informal resolutions? The second is, are you going to provide a hearing? And the third is your standard of evidence. Let's take each of those bit by bit. Informal resolutions. These may be offered to the complainant after the complaint is made, before the determination. It cannot be offered until a complaint has been filed. I cannot offer an informal resolution in lieu of
filing a formal complaint. And it must happen before a determination is made. We can't have a determination and then decide we're going to do an informal because we didn't like the determination.
You cannot require people to participate in informal resolutions as part of their ability to be part of your school or to be employed or any other right that you grant. Informal resolutions must be
Voluntary.
They specifically did not define them so that you have freedom as a school
To determine how that works.
whether it's mediation or some other tool that you have out there. You cannot provide informal resolution if the respondent is an employee of the district and it's toward a student. And if you provide informal resolution within that notice of the allegations, you have to provide the process, what's available to them, and how they can utilize that informal resolution, including what happens when they start it and at what point it precludes them from being able to re-engage a formal complaint against the allegation. So you have to decide, are we going to offer informal resolutions? Are we not?
Hearings. Post-secondary schools must provide hearings. Elementary and secondary schools may, but don't have to. If you decide you're going to do them, here's what a hearing has to have. It must allow live questioning by the advisor only, not by the complainant or the respondent. If either party cannot provide an advisor, then the recipient, the LEA, must provide that advisor free of charge. And you have to keep the parties separate. The benefit of an informal resolution would be something of the effect of, first off, they may say, I've been sexually harassed. I'd like some counseling. I'd like some help. I'd like some support that may help me through this, but I don't want to engage in a complaint process. Another person may say, look, I need the supportive measures, but part of it is I can't be around this person. So I'd like to file a formal complaint, but instead of going through the whole process of you having to investigate everything about my life and potentially the respondent's going to learn things about me through their evidence finding process that really I don't want them to know that may not be relevant, but are related. So instead of going through that whole process where you have to get witnesses and I'd really just have some kind of informal resolution where we can come to an understanding of what went wrong and the steps that need to happen so that this doesn't happen again. I just want it to not happen anymore, but I don't want to just ignore it. And so sometimes they may choose that option because they really don't want to engage in the whole investigative process because of what it takes. I hope that clarified that. And if there's a hearing, you have to allow all relevant questions, which include questions regarding credibility. And then you have to record it and or provide a transcript of the hearing. If you say no, then here's what you need to have. In fact, you need to have this regardless of whether you're providing a hearing or not. You have to have time for additional questions in the hearing that may be spoken or they may have written them. For not doing a hearing, that means that the investigative report comes up and then they can ask additional questions based on what they see from the investigative report. You also have to give time for them to respond to those questions and to have appropriate follow-up. The questions, however, must be relevant. The decision maker determines relevance. One thing that I learned on this, because someone had asked me about it, if you offer hearings, you are not required to offer hearings at all levels. For instance, you could opt to offer hearings for 16, 17, 18-year-olds because you think they could go through that process, but you don't feel that 7-year-olds or 8-year-olds should be cross-examined in a hearing. You do have the capability to make those adjustments as long as you have some consistency and you're able to defend as you give your reasoning for the procedural guidelines. When you give your written determination, you can explain why, but that is one where you have also the ability to engage in hearings at a certain level, but not at another level. Okay, sorry, I had a question about informal resolutions again. Okay, so an informal resolution could result in sanctions. This is really important. An informal resolution is not the same as supportive measures before a complaint. An informal resolution does result in an outcome. That outcome could have sanctions, but those sanctions should be resolved through the informal resolution process. I cannot do an informal resolution that results in some sanctions to the respondent and then determine I want to add additional sanctions, or an informal resolution that doesn't resolve in any, but then I want to engage in sanctions. Whatever outcome happens to supportive measures remedies given to the complainant or actions taken against the respondent must be resolved through the process. The informal resolution is part of that process. However, you cannot, again, you cannot give additional sanctions outside of this process for a Title IX sexual harassment. All right, now we're on to standard of evidence. You must select one standard of evidence. It must be consistently applied. That means you cannot make it harder to prove an allegation against a teacher than it is harder to prove an allegation against a student, or vice versa. Preponderance of evidence. It's one I hear most of the time. That means that you have enough evidence to show that it's more likely to have happened than not to have happened. It could be 51% chance that it happened, 49% chance it didn't. That's preponderance of evidence. Clear and convincing evidence. It's significantly more likely that it happened. Not just possibly, but it's substantially more likely that it's true versus untrue. It is a higher level of evidence than preponderance, but not the level of evidence that is beyond a reasonable doubt. It's not defined as what percentage, just a highly probability, but less than beyond a reasonable doubt. You have to determine which one and apply it consistently. So again, the three things you have to determine: are you going to do informal resolutions? Are you going to offer hearings? And what the standard of evidence is. Now, impact. You have to provide training. There's training that's required, and then we recommend some training. And again, as I've mentioned in my chat, we are providing technical assistance. We are not giving legal guidance. That should be discussed with your counsel. What we are giving you is based on what we've read through OCR. This is a good question. If you're doing an informal resolution, you have to finish the investigative process because they've gone into the informal resolution. That's a big deal. It's a big part of it. Pause any of the investigative process at that point, and witness gathering and answering and all that type of thing. It also doesn't result in a written determination, but a resolution that they've agreed upon, as opposed to a written determination that is the action that will be taken.
My understanding is in an informal resolution, the complainant and the respondent are kind of working together, and they have more of a say, or more of a control on what happens. That's why the examples I have heard is if it's very clear that it did happen and no one's denying that it happened, and there's kind of that agreement, then that's when an informal resolution could happen. But whereas in a grievance process, it's very specific. Once you file a complaint and you go through the grievance process, that there's different steps and there's different personnel involved. Whereas the decision, the investigator does the investigation, gives the investigative report, and then the decision maker makes the decision. So the complainant and the respondent wouldn't have a say on what the outcome is, whereas in the informal resolution, they are involved in that process because they have to be in agreement with what's going to happen in an informal resolution. In a grievance process, you don't even consider that because the decision maker or decision makers are making that decision. So that's just something that you could go back and look at, but that's kind of my understanding of the difference between an informal resolution and a grievance process.
So if the informal process begins, you're pausing the formal process, and then it may be re-engaged, which means the investigation will begin again. Before I give any further, we'd like to get a few more, we need to get back on some of those questions to exactly how and when that pause or start happens, so we don't lead in the wrong direction on that one. So we're going to need to get back and responding a little more detail about the difference between the informal and formal, because we don't want to lead any direction. How they would know, there is a resolution that they make, and that is part of the resolution. Anything that happens has to be part of that resolution that they agree to. So it would be part of the discussion. Your informal resolution facilitator would need to lead the discussion as to what the outcomes will be and what they agree upon as a result of that resolution. And that is essential in that process. Beyond that, we need some more research on how the informal resolution process looks like before we continue on. I might make it a comparison to plea bargain, but I'm not sure that I'm ready to make that particular statement as far as how those things would be compared. If you choose preponderance, does that mean the district has used for all cases? If you choose preponderance, then the district must use this for all Title IX sexual harassment cases. That does not determine what you should use for any other disciplinary action outside of Title IX, but it does for any formal complaint that is filed. And it should be included in your procedures that you have available to anyone to prove that this is the standard of evidence that you will use.
All right, so now for the impact. We're going to cover 4 areas. where the impact affects us, what training needs to happen and to whom. Personnel team, we're going to talk a little deeper into what that personnel team is and what they look like. We're going to talk a little bit more about the timeline and how that looks different than what we may be used to for typical behavioral or other disciplinary issues. And then we're going to look at discipline processes and policies. A little more discussion on FERPA, some other considerations. We're going to look at some policies and definitions across the state. And we're going to actually have some examples and talk about, this is a question and answer. Is it Title IX sexual harassment? Training. You have required trainings. According to the regulations, all team members must have the following training. I'm not going to read every one of those, but those are the ones that you need to have. Notice hearings is if you're conducting hearings, and informal resolution is only if you're offering informal resolution. Investigators, in addition to what all team members must have training on issues of relevance regarding evidence to determine whether evidence is relevant to the allegation.
And then decision makers need to have issues of relevance regarding evidence and questions.
And that again is whether you're doing a hearing or not, they still are providing opportunity for questions. And then if you are providing a hearing, they have to be trained on the technology used in the hearings. We are working on some additional trainings for some of these areas that we are going to be providing to you as we move into the year. This does not preclude you finding other ways to find that training. I know the co-ops are working with some and other legal advice. We are continuing to work, and we'll let you know as we get more of the trainings. We'll have some Zoom meetings like this. We'll also have some on-demand training that we're working on. We'd recommend the following trainings for all employees. This is not required by law. We'd recommend that all of your employees, because they are required to report, we would recommend you define what Title IX sexual harassment is, about the duty to report, how they report, and then basic ideas of your grievance process and your timeline. Again, these are recommended and they are not required by the law. So we've talked about that personnel team. You have your Title IX coordinators, you have your investigators, you have your decision makers. And now that I've talked about the informal resolution process as something that you may or may not option, then you have informal resolution facilitators that are added to this team. If you do not offer informal resolution, then their facilitators are not added to your team. Let's talk about each of those areas. The coordinator, you saw the slide earlier. We're going to focus now on coordinate and responsible. You are a Title IX coordinator. Take a moment right now, and I'm going to go through the things that you have to coordinate and the things you're responsible for. Notice we're not addressing the authorized or the readily available and accessible, which is another list of things. As a coordinator, you're responsible for coordinating the training of the Title IX personnel. You have to respond to all actual knowledge of Title IX sexual harassment. You have to ensure due process throughout. You also have to oversee the implementation of any supportive measures, any remedies, and any sanctions. And you have to ensure recording of all of these items. And I say this, and I'm hoping superintendents are here as well to realize this position cannot just be handed to somebody because you need to add something to a plate somewhere. This is an essential position with a lot of responsibilities. So please make sure the person has the supports they need. You may even want to consider some assistance. The law does not require you to have assistance, but it does not preclude you from having them. If you do have assistance, you do want to designate who is kind of your lead, who is the lead Title IX coordinator, and then have the information out for others. Larger districts especially, you may want to have regionally located or based off of schools. Some have feeder pattern situations, whatever works. You may want to have a few assistants. And if you do, they must be just like the main title coordinator. Their information must be readily available and accessible in the same way through your website and other things that have already been described to you. Let's take a look at the single investigator model. So a single investigator model is something we see a lot in education. It's a process where one person interviews all parties and witnesses, gathers and examines the evidence, and then makes a determination regarding guilt or innocence of the respondent. Typically, that's also the person who will determine what actions are taken against the respondent or remedies provided for the complainant. We see this a lot in education. Assistant principal gets an accusation of some disciplinary thing that has been broken. They interview the student, any witnesses, make a decision, enact a punishment, and there goes the process. Previously, Title IX did not specify an investigation model. However, Starting about 2014, there was a White House task force report that encouraged trying different models. One of the models it encouraged and thought would be worth looking into is the single investigator model. That was from previous guidance. The current guidance specifically and expressly forbids the single investigator model. The investigator cannot be the decision maker. Investigators. So your investigators conduct investigations. They create the investigation report. They cannot be a decision maker for this complaint. Can be the Title IX coordinator, but I want you to think about all those responsibilities the Title IX coordinator has and the need to be unbiased and impartial. Could they be principals or assistant principals as long as they've received the required training? It does not specify who they are as long as they have received the training and are not the decision maker in the complaint that they are investigating.
Yeah, so there's flexibility. So if you're a decision maker in one, you can be an investigator in another, but you can't be an investigator and a decision maker in the same situation. I will tell you, some co-ops are contracting out with retired superintendents or other people in the districts. You can coordinate with other districts. There are a lot of options, but it doesn't specify even if they have to be certified or not.
Decision makers, single individual, panel of individuals. You can even have multiple individuals who adjudicate specific portions of the process. However, the determination or the written decision must be one document put together and presented as one entity. Somebody asked about a school board being an appeal for the superintendent is the decision maker. That would be a panel of individuals dealing with an appeal. Another thing is the first point of appeal cannot go to the original decision maker. There are many districts whose policies are if you have a grievance or a complaint, you should first address the person who made the initial decision to see if they would reconsider, and then you move up the step. While that may work in other disciplinary hearings or questions of personnel or other decision-making in Title IX sexual harassment, it cannot. They have to have an appeal that is not the decision maker. Again, school principals may be the decision makers also for their buildings, provided they are not in any way involved in collecting evidence. So here are two questions, which I don't have an answer for. It's something for you to think about and talk to your legal guidance on this. If they've interviewed any witnesses, are they not then investigators? Can they be unbiased if they're the ones that received the initial report from the student with the emotion that the student may or may not have had in visiting with them? Again, going back to what Ms. Johnson talked about as far as bias, you have to be able to say whether you have a bias or you cannot serve impartially.
Okay, so here's a question. Will this work? Assistant superintendent as Title IX coordinator, district legal counsel as investigator, and superintendent as decision maker. Well, technically, by the regulations, that is something that could work. You have to look at all the answers that are in there regarding the roles that they have and what they have to do. Remember, Title IX coordinator, I'm just going to warn you about just having an assistant superintendent as a Title IX coordinator, depending on the size of your district. Remember all the things they have to do. This is a big job. Formal resolutions, they have to be trained. Doesn't state who they are. Could they be a decision maker, an investigator, the Title IX coordinator? There is nothing specifically listed in the regulations regarding the facilitator. And then, of course, impartiality. Here's another thing. Informal resolution facilitators could be called as witnesses in subsequent formal investigations. You as a recipient will decide whether your formal resolution facilitators could be called as a witness. And if allowed, you have to make it really clear before the informal resolution process begins that they could be called. I don't have a reason as to why they would or wouldn't, but that is a possibility given in the regs. Flexibility. It appears that investigation, decision maker, and formal facilitator, it can be flexible. But we would recommend consistency as much as you can. We just know with different districts, especially smaller ones, that it's kind of hard with the limited resources that you may have as far as personnel. Just make sure that they have been trained appropriately. So don't put someone as a decision maker who has not received the training that the decision maker needs to have. Internal employees versus regional center models, and I kind of already alluded to this. We'd encourage you may consider using the educational co-ops to resource out. You may connect with other districts and say, hey, we're going to train our Title IX people, and we may share them with each other. Be aware that any training that's used to train them, so if you go through a co-op and they provide training to the investigators themselves, you need to get copies of that training to put on your website to make available as part of your team. You cannot contract out the Title IX coordinator. That is the one position in regulations that states is an employee of the recipient. Everything else gives you the ability to be flexible and to be inventive. Timelines, investigation timeline. As I already mentioned, they've got 10 days, no less than 20 days for the timeline, and the appeal, it does not specify. So let me explain why those 20 days. So here's that investigation timeline that we already presented. Down here, under where it says to present evidence, in this section here, I have to present all evidence that is related to the allegations. So I don't present, if I'm reviewing video of another student doing something else that has nothing to do with this allegation. However, if there's something on that video that relates to this allegation, I haven't talked about relevance, just related in any way, I have to make that available to all parties to be able to review. Then they have 10 days to write their submitted response. And then before the investigation report's written, the investigator has to have time to consider all the written responses and then create the investigative report. And at that time, only relevant things. And that's a different training that we're not providing in here. But there are some specific things about what is relevant, and investigators need that training. Then you send an electronic or a hard copy to both parties simultaneously of the investigative report. And notice here, we've got another 10 days for review of the written response. Those written and relevant questions, and this is where the decision maker takes over. The decision maker determines what are relevant questions that are allowed to any party or any witness, and you have to give them time, although limited, but additional time to follow up questions and respond. And then if you're having a hearing. So again, 20 days is the absolute minimum, and that means you can investigate in less than a couple of hours and get that written report right out to them that time. Here we're hearing some who have done it, and the whole process, the person who engaged in it took about, I think, the investigative process, I think, took up about 30 to 40 hours, if what I understand correctly. Appeals. It states that it has to be filed and resolved in a reasonably prompt time frame, but it doesn't tell you what a reasonably prompt time frame is. That is a determination that you'll make. So we look at it. We hear 10 days a lot. 10 days to file, 10 days for a response, or up to 10 days to file. And within that 10 days, we could respond no shorter than 10 days. You have to make a decision. You may say 5, you may say 2, 3. It has to be reasonable, so they have time to actually engage in the appeals process, but it cannot be drawn out. So what about FERPA? We talked about FERPA a second ago. I love this phrase. The obligation to comply with Title IX is not obviated or alleviated by the FERPA statute or FERPA regulations. So what does that mean? That means I have to follow FERPA, except in the notice of allegations, I've got to give the identities of parties. And understand, the notice of allegations will probably be going to the parents of the students because of the parents' legal right to engage in this process, which means I can't say to a parent, I can't tell you who did this. Your child may know, but I can't give you the name of the person who did this to your child. Here's the allegation, and I have to give you the complainant and the respondent, although I have to state in that allegation that I'm not assigning responsibility for the respondent at this stage of the process. However, in the determination, I have to give both parties simultaneously what was given, what happened, including what sanctions I impose on the respondent, which means I cannot tell you what action I took against another student is false in this situation. You must tell them what action you took against another student. And then if remedies are offered to the complainant, not what remedies are offered to the complainant, but there are some that are being offered or provided to the complainant. And then in supportive measures, you need to keep those confidential as mentioned, as long as the confidentiality does not deter your ability to provide the supports. So if I have to do a class change that is not unreasonably burdensome on the respondent, then somebody's going to know something happened. So now let's think of some other questions here. Locations. Locations, events, circumstances, and this is where they are, over which the recipient, you, exercise substantial control over both the respondent and the context in which the sexual harassment occurred. So school, field trips, dances, student events, home events, away events, when do you have control over the context? What about Chromebooks and iPads? These are all things you have to determine when you have substantial control. Let's also talk about some other considerations. Dating violent. You're at a school dance. They're dating. They've been in a relationship and there's violence that happens. It's at the dance. You have control over the respondent and the context. So the question is, does it effectively deny access? It doesn't matter for this prong. This prong doesn't ask about severe and pervasive. It asks, is it dating violence? Yes or no? And does it fit your location? What about stalking? Can students stalk other students? When is it stalking? When is it annoyance? When they have that fear that was described in there. Again, reasonable person clause does not come into play to this prong. It's not in there. All right, and then domestic violence, what's about a staff on a child who is also a student at your school. So again, whether you have to do it if it doesn't happen at campus, then there's other rules and reporting you have to do. And then dual enrollment, kids that are enrolled in college and in high school. What rules? In reading the regs and our recommendation, our understanding is you are a K through 12 institution. Title IX expecting you and defining you as a elementary and secondary education. You're not held responsible for the post-secondary rules.
What I want to do here, because of time, I'm just going to point out a few different policies that we see. And some of these you can tell are part of the ASBA standard policies. So some of these are older policies that need to be replaced. But understand, we talked about all the different definitions of sexual harassment, and you've got to think about, how do I let kids know which sexual harassment we're talking about and what process comes into place? Here's one. Defines sexual harassment, and that was the previous to August ASBA standard policy. District B, very similar. And then they have in there sexual harassment as governed by policy 4.27 is also a form of bullying. But in some websites, I couldn't even find policy 4.27 anywhere on their website. So if you reference it, make sure it's there. Here's another one. You've got sexual harassment, sexual orientation harassment, sexual misconduct, and then yet another sexual harassment that includes parts and processes. We would encourage you to be looking at how you define that and talking to your legal guidance on what is clearly Title IX sexual harassment. And if you're going to use the term for other definitions and make that clear when your Title IX grievance process comes into place. It can be confusing, especially if you're 10. A few other: sexual harassment, or sexual misconduct, displays of public affection. So you've seen all these. Another one that talks about immorality. How is immorality different than sexual harassment? And are they in and of the same? So those definitions that we explain on there. And then someone talks about actionable sexual harassment, which may be when you're talking about Title IX. Is it Title IX sexual harassment?
Using the severe and pervasive objective for that middle prong, it's important that you understand that they list in this case, this is Title IX preamble that says these may be things that show that they have not had equal access, but no concrete injury is required to determine that it would deprive them of that. Davis versus Monroe case is a good one to look at. I kind of flipped through that one. That set up the severe, pervasive, objectively offensive, and denies equal access. There are a couple things I want to mention in this though, when you're looking at that middle prong. Unlike the adult workplace, that children may regularly interact in a manner that would be unacceptable among adults. That what level rise to the level of harassment depends on a constellation of surrounding circumstances, expectations, and relationships regarding ages and other knowledge of the students. And it states that damages are not available for simple acts of teasing and name calling among school children. However, even when these target differences in gender. Title IX could be taken to court and not just OCR, which is damages. So here are a couple samples. Here we go. We're going to do this in the chat. So I'm going to get my chat ready. These are a yes or no question. All right, I'm going to give you a few of these based on what you currently know. Are these Title IX sexual harassment? Here we go. First one. Young man repeatedly grabs and rubs his crotch whenever a young woman enters into their English class. In the chat, what do you think? All right, yeah. So again, we say a lot of yes. The other question would be maybe, because again, does it effectively deny access? This is that middle prong, right? So it could. How about this one? Student yells across the cafeteria, call another student a thought. And for those who don't know, thought is that hoe over there. Okay, so I would assume no is there's a great question. Once. Is this the first time it's ever happened? Is there some background to this? Is there something you're not aware of that's happened? Is this a culmination of events? or something else that's actually denying them access because it's so pervasive? I don't know. You got to figure that one out. But be careful to automatically assume no based on one experience, but it could be. And it's just the only time likely to only be one. How about this one? A student from another school in the district is at an evening extracurricular activity at your school. The student meets a student from your school and repeatedly sends text messages and calls asking for sexual favors. Is that Title IX sexual harassment? It's not a student from your school, but another school in your district. The answer is, if proven true, that would meet the definition of Title IX sexual harassment, because it could fit into those prongs, because the recipient is not the school, but the district. You receive a call from a parent from a student in a neighboring school district. The parent states that one of your students is constantly texting their child inappropriate pictures during the school day. So my question on this one, is the complainant trying to participate in your educational activity? If not, then you must dismiss. Actually, they can't even file a complaint because they're not in. Doesn't mean you don't take other action, but this would not fall under Title IX. How about this one? Student grabs another student's rear end in the hallway between classes. So it's important in this process that the question that was stated in there is the fondling, which this could be considered under fondling, for the purpose of sexual gratification? If it is, there's no objective or pervasive or severe or denial. If it fits the definition of fondling, then it falls under Title IX sexual harassment. So there are other things that may happen with that, but you can't take disciplinary action until a formal complaint has been filed. A couple more and then we're going to be done and we can get to the end here. Substitute teacher hired through a temp agency is accused of only helping young women who have low-cut shirts and lean forward and working with them. That would be what we'd call our quid pro quo. I see the same people responding a lot. Okay, how about a teacher who worked at your school last year, but is now employed by another school, is accused of sending text messages this year, by another district, sorry, to many of the students at your school requesting nudes? Do you have control over the respondent and the context in which, there we go. So not necessarily Title IX. Again, you'd have to look at more details beyond this, but definitely there's some other reporting that you would want to do. A virtual student sends sexually explicit messages and images to another virtual student using the school provided device. It's your device. You've given them the context and what defines itself as reasonable control. Again, these are questions you should ask further with your legal guidance on this. We want you to think about it. What if they're doing it during school time, but they're both virtual students and they do it through their cell phones? Do you have control of the context because it's during school time, even though they're not on your campus? Questions that you would want to ask and talk to your legal guidance on. Again, it's not defined as sexual harassment. You must dismiss the complaint. However, that dismissal does not preclude action under another provision of your code of conduct. We've also given a little bit of a checklist to make sure you've got things going and are getting ready to start up and get moving on Title IX. For your time and what you've done for us and coming and listening and giving us your feedback and questions.
Thank you for joining us this morning. I have a couple of questions for the school districts. There's a change in the procedures, as we talked about. No school operates safely without policies and procedures. The U.S. Department of Education Office for Civil Rights is demanding that school districts implement procedures in order to be in compliance. Now you must make changes in your procedure to comply. I think it has already been stated several times that we are not legal advisors for the school district. We are technical assistants. My question comes with, how familiar have you made your staff aware of Title IX? If they don't know the requirements of the law, how will your school district protect the students and the staff, but protect the students from, number one, violating the law, number two, knowing when they have violated the law? And if the law is being violated and a student does not know, if the law is being violated and you have inappropriate, substandard, no procedures to comply with the law, who's in violation of the law? My question is, how prepared are you as a recipient of federal financial assistance in complying with the law? Yes, I know that August 14th, I believe, was a short time, a short notice, but now that you know, what are you doing? We are technical assistance. We are offering you the best we can possibly offer in regards to what we've received from the U.S. Department of Education Office for Civil Rights. So what are you doing in documenting? You must have documentation. If you don't have it documented, it didn't happen. I have to use the word ignorance, but ignorance of the law excuses no one. So are you in compliance? We are here to assist you, technical assistance. If you don't contact us, ask us for assistance, there's not much we can do. There's a form that we're working on, aren't we?
We are working on some technical assistance forms and checklists that we may give out. I think ASBA is working on some legal documents that would help you through the process. So we're trying to get some things out.
Thank you again for joining. Thank the Equity Assistance Center staff for shining a light on Title IX, and hope to hear from some of you real soon. Have a great day and please be safe.